Chapter 5: Location of Case Participants and Their Assets. Chapter 5: Location of Case Participants and Their Assets. Introduction. To establish the parentage of a child, obtain a support order, or modify or enforce an existing support order, a state or tribal child support agency must have adequate and accurate information. For instance, it is important to know the whereabouts of the child, the home and/or work addresses of the parents, and information about the parents' assets. Sometimes the agency may obtain the necessary information from the person receiving services. However, this person often lacks adequate information to start the necessary legal proceeding, and more research by the child support agency is necessary. Having a valid location for a non-custodial parent is essential. It allows the attorney to determine which state has personal jurisdiction over the non-custodial parent. In addition, in intergovernmental cases, information about the current locations of the individuals is critical for determining continuing, exclusive jurisdiction sedge. As in any legal matter, due process in a parentage or child support proceeding requires the responding party to receive notice of the legal action and to have the opportunity to respond. A correct address for the responding party is necessary to either personally serve the party or effectuate service in accordance with state law. If the child support service recipient cannot supply the address, the agency must try to find it. In addition to the physical location of the parties, the state or tribal child support agency needs information about income, employment, and assets. Such information is critical for setting appropriate support amounts, as well as for modification and enforcement purposes. Because many sources of income and asset information are hearsay, child support attorneys must be aware of the rules regarding the admissibility of evidence in their jurisdiction and the burden of proof required to establish the facts in each particular case. The process of obtaining information concerning the physical whereabouts of a parent, parent's employers, or other sources of income or assets to take the next appropriate action on the case is known as location. For parentage or child support purposes, the term locate encompasses a broad spectrum of activities that occur throughout the life of a case. These tasks can be complicated by increasing mobility in American society. However, modern technology has made locate activities much less labor-intensive and more efficient and effective. Widespread electronic record-keeping, databases, and service delivery in the public and private sectors have led child support agencies to rely on highly automated locate activities that access these resources. Electronic locate activities provide very cost-effective and timely data on location of parents and identification of their assets. Despite the necessary and pervasive nature of the locate function, the role of child support attorneys in locate activities is limited due to the highly automated nature of the locate function. From the perspective of child support attorneys, locate activities may seem invisible, occurring electronically behind the scenes of legal case activities. However, child support attorneys need to be familiar with the powerful automated locate resources available to the Roman 4D agency. And like other child support staff, attorneys play an important role in protecting privacy, confidentiality, and security of sensitive and protected case information, including locate data that may impact the safety of parents and families served by the child support agency. Locate capabilities of automated systems. Federal law, regulations, and policy require state child support systems to interface electronically with a large number and wide variety of sources to obtain and verify locate, asset, and other information on parents served by the child support program. Data from individual state systems is linked through federal systems, so that data may move electronically between and among systems. For example, the Federal Parent Locator Service (FPLS) accesses an expansive array of helpful locate resources and records and interfaces with each state's State Parent Locator Service (SPLS). Also, each state's State Case Registry (SCR), a central registry of child support cases and orders in the state, provides and receives data from the Federal Case Registry (FCR), a national database that contains information on individuals in child support cases and child support orders, including data from other states' SCRs. Data from this resource assists child support attorneys in determining the controlling order and in identifying any other orders affecting parties in a case. Another similar example is the Federal National Directory of New Hires (NDNH). It provides federal agency employment data and connects with state directories of new hires (SDNH). Information from these sources includes far more than address and employment information. Automated systems may also identify financial institution accounts for those who owe support and data related to services or income from other government agencies, such as child welfare services, Social Security disability insurance benefits, unemployment benefits, and military service benefits. See Exhibit 5.6 for the automated interfaces required for state child support systems. In addition to required interfaces, state child support systems may elect to interface with the AUX Child Support Portal, which provides additional functionality. See Exhibit 5.7 for locate resources available through the portal. The data obtained from automated systems assists child support attorneys in identifying and locating parents and other parties to litigation, and in identifying assets that may be used to enforce unpaid child support orders. For intergovernmental cases, the federally operated CSenate system electronically connects state child support enforcement CSE automated systems to conduct interstate case business activities. Federal requirements also mandate that automated systems record, maintain, and track locate activities to assure compliance with federal program standards, including mandated timeframes. The tracking capability includes automated prompting for the next appropriate case action. And when new information is added or changed in the automated system, such as the loss of employment, it automatically resubmits the case to electronic locate sources. The requirement for electronic monitoring and recording of locate data is ongoing through the life of a case. Tribal child support programs may operate automated systems themselves or may have intergovernmental agreements with state child support agencies. In 2014, Congress authorized tribal access to the FPLS. In 2016, AUX issued a Dear Colleague letter describing the process for tribal Roman 4D programs to access the FPLS. Locate resources beyond state and tribal automated systems. The number of electronic and other locate tools available from state and federal sources has grown tremendously in recent years. However, there are certain child support case participants who may not appear in government databases. These include individuals who work in the underground economy for cash, do not file tax returns, work in the gig economy, do not own titled personal or real property. Locating these parents requires more effort beyond reliance on state and federal automated resources. Personal contacts. Those who know the non-custodial parent personally may have useful information for the locate effort and should be considered an important resource. These include the other parent in the case, relatives, friends, unions, fraternal organizations, and current and past employers. In addition to helping locate the non-custodial parent, personal contacts like these may provide information about the parent's employment and earnings history and other information related to the parent's ability to pay support. Local tribal child support agencies may be good sources of information if the state child support case participant is, or may be, a tribal member. Even when the state case participant is not a member of a local tribe, local tribal child support workers may assist in contacting child support workers of tribes in the area where the state case participant resides or works. Those workers often can provide useful information. Local electronic resources. Although many local governmental services must interface with child support automated systems, see Exhibits 5.6 and 5.7, some are not. Access to their data may require contact and cooperative agreements with a particular agency within the county, state, or tribal government. For example, court records and real estate and personal property data may be available through the county clerk's office or registry of deeds office. Private sector resources. States and tribes may also contract with private sector entities to provide locate data electronically. Social media. Under the proper circumstances, and with the proper safeguards, social media sites may be useful sources for locating child support case participants. Courts have upheld the use of social media sites for location of parties in cases, and some child support agencies have begun using social media sites for locate purposes. In addition, some child support attorneys have used social media for service of process where traditional means of service are ineffective, and where authorized by state law and court rules. Child support attorneys wishing to use social media to locate case participants should be aware of and follow existing ethics and evidentiary rules. Obtaining locate data. One way to obtain electronic communications that assist the locate function is to contact the service provider directly. However, attorneys need to be aware that the Electronic Communications Privacy Act of 1986 states that an entity providing an electronic communication service to the public shall not knowingly divulge to any person or entity the contents of a communication while in electronic storage by that service. There are exceptions to this rule, but courts have found that this section lacks any language that explicitly authorizes a service provider to divulge the contents of a communication pursuant to a subpoena. Federal law requires states to have procedures that allow child support agencies to subpoena financial or other information from entities, such as public utility companies, cable television companies, financial institutions, and state tax offices, and to impose penalties for failure to respond to the subpoena. Federal Rule of Civil Procedure 26 makes it clear that electronically stored information is subject to discovery, just as other types of information can be discovered. Since there are no rules that specifically apply to electronic sources, existing ethics and evidentiary rules apply to the discovery of electronic and social media information. Privacy, access, and security. Information obtained by the Child Support Agency about the location and assets of case participants is sensitive and personal. Confidentiality of information handled by the agency is very important. Federal law and regulations contain specific rules for protecting the confidentiality of data obtained and used by child support agencies. Authorized disclosure of confidential information. Confidential information may be disclosed to authorized individuals or agencies depending on the purpose for which the information is requested and the agency or person requesting it. The child support agency must provide locate services, if necessary, in a child support case. According to federal regulations, in any case with an application or referral to the child support agency, the child support agency must attempt to locate all non-custodial parents and/or their sources of income and/or assets when location is needed to take necessary action. This is known as full locate, and it requires that the state use all local, state, and federal sources necessary to locate the individual. Sometimes, the child support agency may provide locate services to individuals involved in custody and visitation cases. Federal law authorizes the Child Support Agency to transmit locate requests to the FPLS to make or enforce a custody or visitation order in certain situations. These requests must come from a court with jurisdiction to make or enforce a custody or visitation determination, or from an agent of a state or the United States with authority, either to enforce a custody or visitation order, or to prosecute an action for unlawful taking or restraint of a child. As a result of the passage of the Adoption and Safe Families Act of 1997, federal law also provides for the use of the FPLS for location of any individual who has or may have parental rights to a child. The Act also allows the release of FPLS information to State Roman 4B child welfare agencies or State Roman 4E foster care agencies. Pursuant to federal regulations, requests for information from the FPLS must come through the SPLS. However, authorized federal agencies may either contact the FPLS directly or go through the SPLS for locate information under the terms of an agreement. Confidential data obtained through the SPLS may only be disclosed to authorized individuals for authorized purposes. Even then, only limited information may be released. See Exhibits 5.2 through 5.5 at the end of this chapter. Authorized non-federal entities must request information through the SPLS, which obtains the information from the FPLS and returns it to the requester. The fees for this service are paid in accordance with 42 U.S.C. 653(e)(2). The SPLS must distinguish requests for custody, visitation, and unlawful taking from those for child support purposes so that only authorized information is released. Child support purposes. Child support purposes include location of an individual for the purpose of establishing parentage, establishing, modifying, or enforcing child support obligations, and location of any individual to assist a state in carrying out its responsibilities under the Title Roman 4D program. Child support purposes also include the location of a parent or child involved in a non-Roman 4D child support case. Authorized persons for child support purposes include any state, local, or tribal agency providing Title Roman 4D services, a court that has authority to issue support orders or act as an initiating court or the agency of such a court, or the resident parent, legal guardian, attorney, or agent of a child not receiving TANF assistance, as long as the person receiving the information makes certain required attestations and pays the required FPLS fee, if the state does not pay the fee itself. It also includes an entity designated as a central authority for child support enforcement in a foreign reciprocating country or a treaty country under 42 U.S.C. 659 AC2. Child welfare or foster care and adoption purposes. Authorized purposes for child welfare or foster care and adoption purposes include the location of an individual for the purpose of determining who has or may have parental rights to a child, and the location of an individual to assist states in carrying out their responsibilities under the Roman 4B and Roman 4E programs. Authorized purposes may also include the location of a child or the relative of a child. The information that is provided is limited in scope. Authorized persons for this purpose are the state agency administering the child welfare program under Title Roman 4B or the foster care and adoption program under Title Roman 4E. Child custody and visitation or parental kidnapping purposes. Federal law also authorizes the use of information from an SPLS or the FPLS to locate a parent or child to enforce a custody or visitation order, or to respond to the unlawful taking or restraint of a child. The information that may be shared is also limited in scope. Authorized individuals for this purpose include an agent, an attorney, a court, or an agent of a court of any state who has the authority to enforce a child custody or visitation determination, or to prosecute a case of unlawful restraint or taking of a child. Authorized computerized data sharing. Statewide automated systems are also authorized and programmed to share confidential information with medical assistance agencies, state child health insurance programs, and the Supplemental Nutrition Assistance Program SNAP. Independent verification. In general, location data can be shared and used within the child support program and may be shared with certain related federal programs. Although the regulations allow most information to be shared directly with permitted agencies and entities, in some circumstances information may not be shared unless it has been independently verified. Independent verification is the process of acquiring and confirming confidential information through the use of a second source. IRS information. In addition to the safeguards described above, child support attorneys need to know that any information obtained from the IRS cannot be disclosed, unless it is independently verified or otherwise authorized in federal statute. Information obtained from the IRS, known as Federal Tax Information (FTI), includes any information about the taxpayer's identity, and information regarding income, deductions, exemptions, and other related information from a tax return, claim for refund, or other related information. States must have safeguards in place to prevent the unauthorized use or release of IRS information. Prohibited disclosure of confidential information. Information in the FPLS, and information resulting from comparisons using such information, shall not be used or disclosed except as expressly provided in Section 453 of the Social Security Act. In addition, information from the FPLS may not be disclosed where the disclosure would contravene the national policy or security interests of the United States or the confidentiality of census data. Disclosure is also prohibited when a state has notified the Secretary of Health and Human Services that there is reasonable evidence of domestic violence or child abuse, and that the party or child may be at risk from the disclosure. In such cases, the information may be released to the appropriate court to determine if the information may be safely released to the requester. Federal regulations also specifically prohibit sharing confidential information with private collection agencies (PCAS). Under the regulations, the definition of agent of a child now means a caretaker relative having custody of or responsibility for the child, eliminating the possibility that a PCA is permitted to access this information. Family violence. Research from state child support caseloads indicates that more than 1 in 3 parents in the child support program have experienced violence from the other party on their case. In expanding the locate tools, Congress recognized this problem. One concern was how to balance the legitimate need for information about a person involved in a case with that person's possible risk of harm. This concern for victims of domestic violence or child abuse, collectively known as family violence, prompted Congress to restrict disclosure of FPLS information. If there is reason to believe disclosure of locate information in the FPLS could lead to physical or emotional harm to the party or their child. Family violence indicator. As noted above, federal law prohibits FPLS information from being disclosed to anyone if a state has notified the FPLS that the state has reasonable evidence of domestic violence or child abuse, and the disclosure of information could harm the custodial parent or the child. This notification of possible family violence occurs when a state sets a family violence indicator (FVI) in the SCR on the person or persons requiring protection. Each state determines whether a person should have an FVI designation depending upon its law and procedures, so the impact of the FVI differs by state. At the federal level, the existence of an active FVI precludes disclosure of FPLS information. This means that the FPLS does not disclose any matches to state child support agencies for data about the person. Alternately, if a locate request is made for a person protected by an FVI, the requesting SPLS receives a response that disclosing the data is prohibited. This same message will appear when a state attempts to query a case with an FVI in the Query Interstate Cases for Kids Quick system. It is important to remember that a child support agency should place an FVI designation only on the person and/or child needing protection from the perpetrator of the violence or abuse. An FVI prevents all matching and locate requests for people who have an FVI. Therefore, an agency should not place the FVI on the entire case or on the perpetrator, since this will prohibit a state from receiving locate or match information on the perpetrator. Override process. Notwithstanding a person's safety concern, there may be a legitimate reason for data disclosure in certain circumstances. Federal law permits the FPLS to release information about a protected person to a state court under certain conditions. This process is known as the FV indicator override. The override process gives OCS legal authority, on a situation-by-situation basis, to retrieve and release FPLS data that, because of the FVI protection, would not otherwise be subject to disclosure. The court can then assess whether disclosure is appropriate. It is important to note that an override does not remove the FVI from the FPLS, and only an authorized person, as defined by Sections 453C and 463D2 of the Social Security Act, may make the override request. As shown in Exhibit 5.1, the override process involves activity at both federal and state levels. Thus, state child support agencies and courts must develop procedures for the state portions of the process. An authorized person may petition a state court for a one-time override of the FVI, so that the requester can secure the sought-after information from the FPLS. The court will decide to grant or deny the requester's petition. If the court decides to deny the request, the process ends there. If the court decides to grant the petition, it will prepare an order or request to that effect and provide the override request to the SPLS, according to 45 CFR 30370. the SPLS must determine whether the request was made by an authorized person under Sections 453C or 463D2 of the Social Security Act. If it was, the SPLS must also confirm that the request was for an authorized purpose as set forth in Sections 453A2 and 463B of the Act. If the SPLS confirms both prerequisites, the SPLS should send to AUX 1. The court request for locate information, and 2. A cover letter via a special delivery mechanism, such as Federal Express. AUX will receive, review, and verify each FBI override request. Based on that review, AUX will make one of three possible determinations. 1. The request is incomplete. 2. The request is approved. Or 3. The request is disapproved. If the request is approved, AUX will communicate the approved status to the requesting SPLS and then will process the override. Once AUX approves an override request, AUX will perform a one-time manual override of the FBI using the requested locate sources. AUX will return the locate information to the SPLS with a cover letter. In addition to the information secured through the override, AUX also will include the identity of the state that imposed the FBI for the individual. AUX then will forward the letter to the requesting SPLS in a secure package. AUX will also notify the state that originally placed the FBI of the state making the override request. Upon receipt of the package from AUX, the SPLS must disclose the information to the state court that ordered the FBI override. Section 453B2 of the Act requires the state court to determine whether disclosure to any other person of that information could be harmful to the parent or the child. To help the court determine the level of harm associated with possible disclosure to the requester, the child support attorney may be called upon to provide information, if known, about why the FBI was set. If the authorized requester is the child support agency, for example, the FBI has been set on the noncustodial parent, and the agency is seeking to enforce a child support order. The child support attorney must also present a case outlining how the data will be used and why that use is not likely to result in harm to the parent or child. If the state court decides that release of the information could be harmful to the parent or child, the court must deny the request and not release the information. The court and/or the state Roman 4D agency should consider procedures for the destruction of the information retrieved from the FPLS. If the state court decides that the information from the FPLS would be unlikely to cause the parent or child harm, it may release the information to the authorized person who requested the information. The state court and/or Roman 4D agency should develop procedures for the release of the information. A child support attorney may be called upon to assist in developing such procedures. In developing such procedures, the agency and child support attorney may want to address notification to the person whose location information has been requested, notification to the requester of the confidential nature of the information and its limited use, and the destruction or seal of records containing the information, following its release pursuant to the court-authorized request, removing the FBI designation. If appropriate, a child support agency may remove the FBI designation from a case member by removing the indicator from the case member in the SCR. If more than one state has set the FBI on an individual, the FPLS will not remove it until all states involved have removed the FBI indicator from the case member in each state's SCR and sent the change to the FCR. After the FBI is removed, the FPLS begins processing locate requests and conducting matches for that person as usual. The FPLS also removes an FBI indicator when it deletes from its system a person on which an FBI was in effect, or when it deletes that person's last remaining or only case. Conclusion. As this chapter discusses, child support professionals and attorneys have a vast array of resources available to them, locating case participants and their assets. After the child support agency has located the person and/or assets, a case can proceed to the next required establishment or enforcement action and ultimately result in financial support to the family.